Hi there and welcome to ET Now. I'm Ashwin Mohan and you're watching Amicus Curiae. This week, we're going to take a closer look at the ripple effects and implications of a landmark order that has been passed by the Supreme Court on the functioning and regulation of multinational accounting firms operating in India. There are a lot of tough questions that have been asked. The Supreme Court is clearly not happy with the entire oversight, which they call it, that has come in from the accounting regulator, the ICAI. They are also not happy with the extent to which the entire functioning of multinational accounting firms has been probed by some of the regulatory and enforcement authorities. So to get a better sense of what this order means for the accounting community and what are some of the ripple effects as far as the government's responsibility is concerned, because let's not forget that the Supreme Court has also asked for a special committee to be set up to look into the matter. Joining us on the show this week is former ICAI President Ved Jain. Mr. Jain, thanks so much for taking out time and joining me on the show. Let's kickstart, sir, by talking about some of the stern observations in the Supreme Court order as far as the ICAI is concerned. Now, the Supreme Court has pulled up the ICAI, saying that the regulator's committee of experts did find that multinational accounting firms were in fact involved in violating ethics and law, but took a hyper-technical view in absence of complete information, and since such groups were not registered with them, they were outside its disciplinary jurisdiction. That's what the Supreme Court has said. They're clearly not happy with this, and in fact the Supreme Court has gone on to say that a premier professional body cannot limit its oversight to technical issues and is expected to play a more proactive role. They clearly want further examination by the ICAI, Mr. Jain. So my question to you is, under the circumstances, do you think the ICAI as the accounting regulator perhaps needs to be equipped with more powers under the statute to act not only against erring partners but also erring audit firms? And what does it do if its hands are tied? Some of these firms are not registered with it. So what does it do going ahead?
See, that's a challenge which is before the ICAI. You will recall that in the year 1949, this ICAI Act was enacted by the Parliament to regulate the profession of accounting. And while regulating the profession of accounting, certain powers have been given to the institute to how to regulate and how to control and how to discipline and how to take an action against the errant members. Now, over a period, the experience has shown that it is not only the errant member, because of the growth in the firms and the size and multinational operations being now vogue. So the issues have arisen how to control not the member but also the firm. So it is not that what I will say that Supreme Court has pulled up the institute. It is the issue that Supreme Court has raised a concern that looking to the present scenario and looking to the fact that there was a report which was given by a group constituted by the ICAI, whereby they have called information from certain multinational firms which were operating in India in the so-called various names, and certain firms have not submitted the information. The ICAI should not have then sit down there and they should have gone further. And taking into account the fact that under the Act their powers are limited, that's why they have said in the, when you read that what they have recommended in the final paragraph, a constitution of a 3-member committee by the Union of India, and to see that how these provisions can be made more effective and how ICAI can be more empowered so that it is in a position to effectively take action against the errant firms. So I will not say that it has pulled up the ICAI, but it has realized the need. Yes, the time has come and it has considered the present provision of the Act and do agree that yes, the present provision in the ICAI Act are not sufficient enough, and that's why the institute need to be empowered more. The constitute a committee and to come out with an amendment on this line. So that's the right step I believe the Supreme Court has suggested, and that's the need of the hour as on date.
Mr. Jain, thanks for your preliminary comments. Now I want to draw a global parallel. What's the scenario in overseas jurisdictions when it comes to the regulation or the supervision of domestic regulators when it comes to multinational accounting firms operating in their territory or in their jurisdiction? What's the scenario globally?
I will say that over a period, I will see there have been changes. But for this, we need to understand what are the structures outside India. The outside India, by and large, accounting bodies are just like a society being managed by the profession itself. As against this, in India, we have an Institute of Chartered Accountants of India Act, which is enacted by the Parliament. And then we have an oversight ministry, which is the Ministry of Corporate Affairs as on date. The institute is run by a council, it is administered by a council, where 20% members come from the government as a government nominee. Now the council has 40 members, and out of which 32 are elected members and 8 members are nominated from the Comptroller, Auditor General, the Ministry of Corporate Affairs, and then we have Ministry of Commerce also, and then we have Ministry of Finance also. Their nominees sits on the council. It is not exclusively within the profession, there are government nominees also. So is the disciplinary board, where there is a member of the board, disciplinary board, which is nominated by the Government of India. There is a disciplinary committee where 2 members are nominated by the Government of India. Then there is an appellate tribunal of the disciplinary, which is headed by a retired Supreme High Court judge. And then there are nominees of the Government of India also. So it is not the position did. As regard your question that what is the position outside India, I see over a period oversight board has come up in many countries. And that's why they look into overall impact and what's it. So England has also got a separate financial council which looks into all those issues arising thereon. But still, to regulate and discipline the member is within the jurisdiction of the member body itself. You will appreciate it is not a discipline of a crime, etc. It is a discipline of the professional misconduct. It is a negligence while carrying out the attest function and while as performing as a member. So it is an expert body to which one belongs to, which can deal with this subject, because they can really appreciate it. It looks sometimes easier that there should be an outside body. But you see, in case you want to see a doctor, what the doctor has done something wrong, it has to be a body of a doctor which can look into what my fellow colleague has done, whether it was appropriate at that point of time. Similarly, when we look at a chartered accountancy profession, an accounting profession or auditing profession, it has to be an expert body of the auditor itself which can say, look, these are the normal standard and you have deviated from the standard. There is your negligence, there is a gross negligence on your part. It cannot be an outsider can say, yes, no, it is a negligence. For him, it will not be, I will say, he is not having the core knowledge and the basic knowledge of the subject to decide on that issue. That's why I say the international scenario is exactly on the same line, except in the case of a listed company where, as we say in America, we have an oversight board, and that to deal only where there is a public interest, not in all entities, as we say.
Right, Mr. Jain, now the Supreme Court order also seeks examination of potential violation, if any, by the multinational accounting firms when it comes to Section 25 of the CA Act. And this is a section which looks at whether remittances from outside India have been received by CA firms, or remittance of license fee or network charges outside India have allowed the participation of a foreign company or a foreign entity in the accounting business. And also there's a second aspect as well, and that's the aspect on examining whether there's been any potential violation of Section 29 of the CA Act. And that's where one has to see whether common brand name has been used by network firms, whether it's in violation of reciprocity as stipulated under the section. Mr. Jain, what could be the penalty or action that could be potentially taken against these multinational accounting firms if they are indeed found in violation of these two sections of the CA Act post the probe?
See, for this we need to first understand what these three provisions are, how these firms have been operating and where is a violation, and what the Supreme Court has noted. Section 25 of the Institute of Chartered Accountant Act clearly says that nobody can be practiced as an accountant as a company. So there is a prohibition to carry on the accounting profession as a company. So one of the allegations against this multinational firm is that they are operating as a corporate, as a company, because for an attest function there cannot be a limited liability, and in a corporate entity the liability will be limited. That's why the Act prohibits that no chartered accountant can practice or can be a profession as a company. It has to be an individual or a partnership firm where the liability is there. So there has been an issue on this multinational firm as per the report of the ICAI group constituted in 2011. Yes, these people are operating as a company, also that's why there is a violation. As regard your second issue, that there have been a remittances, etc., it is a clear violation of FDI regulation. See, what has happened is, as per my understanding is, that all these firms came to in India and obtained a permission from the Reserve Bank of India for providing management services only. Since accounting, auditing, taxation are prohibited under WTO as on today also, So no multinational firm, outside firm can come and operate as accounting, auditing or taxation firm in India.
Right.
Now what they have done is they have come in India, or got a license from the Reserve Bank of India that we want to do management services, which is allowed under WTO. And they set up a parallel firm where they are doing accounting and auditing with some of the Indian chartered accountant. So there they have been. And in the process also, since some of the firms were not doing well, they have received remittances from abroad by way of what we say contribution. But the Supreme Court has raised the red flag, whether it is a contribution or an investment, that's an issue. And that's why they have, I said they have also asked the enforcement directorate, the complaint they have registered back on this issue, the remittance having received, to take it to the logical and to decide this issue within a time-bound manner. So that's another violation. So far, Section 29 of the Institute of Chartered Accountant Act is concerned, that's regarding the mutual recognition. Because Indian chartered, we do not allow foreign chartered accountant to operate in India, because unless those countries allowed Indian chartered accountant to operate outside India. So one of the issues under 29 was that institute can allow to those members from those countries where there is a reciprocal arrangement. So now many of the accounting firms have people, and these firms are located in those countries where the Indian chartered accountant are not been recognized. So that's there is another violation of Section 29. And there is another violation on ethical sides also, because there is when you see a profession has to work within certain ethics. There is one law, then there is an ethics which puts a moral obligation, which puts a behavior, conduct obligation on a member to behave in a particular manner. And that ethical standard lays down that no profession can advertise, cannot solicit the business or the profession or the accounting work. So what the Supreme Court has observed on the basis of the report of the group is that what these firms are doing is, in the garb of setting up a separate corporate entity, those corporate entities having a common name are advertising, soliciting business, and then passing on that professional work to a firm which they have incorporated or which they have registered in India. So in a way, it is a tacit arrangement which is going on, and in substance there is a violation. In the form there may not be violation, but in substance there is a violation of the ethical standards also. So that's why they have said that yes, these are serious issues when there is a common office, common infrastructure, common telephone number, common email IDs. So why these firms are being allowed to be operated in the manner, and there is a violation, and that's why the action need to be taken. So that's a observation of the Supreme Court. I believe that's what I have read from the judgment.
Right, Mr. Jain, now let's move beyond the ICAI and its role and what the Supreme Court expects, and let's look at some of the other regulatory and enforcement agencies. Let's talk about the ED, or the Enforcement Directorate. The order also speaks about the role of the ED. The order says the investigation by the Enforcement Directorate is pending, though several persons are said to have been investigated, documents collected, and the investigations which are ongoing relate to alleged FEMA violations. Mr. Jain, does the ED have any jurisdiction in India to act against multinational accounting firms? Is there any precedent to this?
Yes, sir. ED has all the power. You see, there is a Foreign Exchange Management Act which has been enacted by the Parliament, and under the Act, RBI has been given powers to issue circulars and concession and clarification. And violation of the FEMA Act and the RBI guidelines is to be monitored and enforced by the Enforcement Directorate. In the present case, as you read the judgment, there are issues which are arising in, and where the ED has registered a case also, that certain remittances have been received which are quite substantial in the number and the amount also have been received. The objective of these remittances in one of the case was to take over one of the running firm, CA firm, and that's why they say it is more in the nature of a capital contribution which is prohibited under FEMA. So it cannot be, because what is being said is that it is a contribution. I go a step forward. Even under FEMA today, I as an Indian resident can receive foreign exchange from a known sources for the non-objective. But in case any non-resident is giving me any contribution, I need to report and obtain a prior approval. If I am doing export, then it is the RBI. But even for a charitable work, even for an entity otherwise, there is a Foreign Contribution Regulation Act also, because nobody can receive donation or contribution or gift from outside India unless you have a permission from the FCRA authority, which is the Home Ministry. So that's it. There are serious issues on this foreign contribution being received unless the nomenclature and the nature of these are there. If I render services to a non-resident, I receive my fees, there is no issue. But in case it is a contribution or it is a capital contribution or it is a gift or something like this, then there are serious issue of the violation of the FEMA Act.
Right, Mr. Jain, hold on to your thoughts. It's time now to slip into a short break. On the other side of Amicus Curiae, we will continue to dissect the impact of the Supreme Court order on the functioning and the regulation of multinational accounting firms operating in India. Stay tuned and keep watching the show. Welcome back to Amicus Curiae, and I have with me former ICAI President Mr. Ved Jain dissecting the Supreme Court order on multinational accounting firms. Mr. Jain, now let's speak about the other aspects of this order. In fact, it's a far-reaching order because the Supreme Court also says a case has been made out for further examination by the central government with regards to any issues of violation of RBI/FDI policies by what it calls as secret arrangements. Mr. Jain, the order also speaks about investment in CA firms in prohibition of FDI policy by using a circuitous route of interest-free loans to partners. What's your take on this observation by the Supreme Court?
See, I believe this is a very serious issue which has been taken note by the Supreme Court. And when you were just reading out, you will look into the sentence which is being ruled. There is a secret arrangement. Now you see, when there is an arrangement which in form is different and in substance is different, then it becomes a matter of investigation. And in these cases, it is its substance which will prevail. Now, if I give you a money which is as a loan, and which you use that money for taking over certain firm, the real objective of mine is to take over that firm, and that's why I'm using an Indian resident, providing him the money, that so he uses the money and hold that investment, hold that firm on my behalf. So Supreme Court has taken a note that there may be an issue, because the petitioner has alleged in that case that the issues are arising on Benami transaction or Prohibition of Transaction Act also. Because in case a foreign entity has funded an Indian resident for taking over or making certain investment in a partnership firm or a firm of a professional, but the real owner of that firm is the foreign entity, then the name, the person in India resident will become a Benami Dar and the real beneficiary will be the foreign entity. So it is a serious violation, and the Benami Act clearly says we need to look into the substance rather than the form, because in form Benami Dar will always be the owner. It is the beneficial owner which will be behind the curtain. That's why the Supreme Court says that this matter need to be, secret arrangement need to be looked into.
Right. Now the Supreme Court order also talks about public interest and rule of law, and it says that absence of adequate oversight mechanism over multinational accounting firms has in fact resulted in several scams which have infringed public interest and rule of law, which are part of the fundamental rights under Articles 14 to 21. And very interestingly, they have also said that it appears that the time has come to separate the auditing business from the consultancy business to ensure independence of the auditors. What kind of an impact do you think this will have if this is eventually put into place, Mr. Jain?
I see that, these type of issues are going on since long, I will say. What we could normally call in our circle on this issue is a conflict of interest if as an auditor you are rendering incidental services to the client for which you are supposed to certify the account. And there is a possibility that a person who is carrying out this attest function or auditing function, he may get carried away by his interest which he incidentally has because of the management or consultancy or other services. So this is an issue which is being debated out since long on the issue. Supreme Court has also observed that in the public interest, the attest function and the auditing function need to be segregated. But then they have also observed that these are a policy decision. And as a court, we will not like to come into the policy decision. We leave it to the Union of India to take a call on this issue. Though they have given their mind on that also, that these being a public interest issue, their scams having taken place, so the government need to look into, and that's why I believe they have suggested that instead of coming out themselves and giving some direction, they have said, let you please constitute a 3-member committee in order to that committee to be effective, in order that what they want to communicate to be really implemented. They have given a time-bound plan to the government. They have said that within 2 months you constitute the committee, and that committee should come out with the report within the 3 months. So it's a message to all concerned, whether it is the Union of India, whether it is the Enforcement Directorate or the Reserve Bank of India or the ICAI, that please get up, make your all issues. We do appreciate that you have some problem with your present enactment. We do appreciate the role of the profession. We do appreciate that accounting jobs are to be taken care of as a rule of law, because the citizen interest is the supreme interest, and that should be ensured. But all you gear up together and work in a manner where these types of conflict can be avoided, and so that the public can have more confidence in the document which are attested by the chartered accountant.
Mr. Jain, the Supreme Court also speaks about the Sarbanes-Oxley Act, and that's where I want to ask you, is there a need for domestic regulations to perhaps absorb parts of the Sarbanes-Oxley Act, wherein corporate leaders are required to personally certify the accuracy of financial statements? The Supreme Court, the top court of the land, has clearly nudged the government in this regard. Your views, sir?
I am frankly personal of the opinion that in India the law as on date should not be over-regulated. You see, we need to make a distinction between what we get from abroad or in foreign countries and what we are having in India. As I stated earlier, the Institute of Chartered Accountants of India Act is not a society or a private body. It is a regulator created by the Parliament under the Act of the Parliament. Only one thing, and what is its administration, management, regulation has been given to a council, which is an elected body. Apparently, it appears to be that one is regulating the profession oneself, they are the owner of that itself. It is not so. That elected body has a 32 member, and there are 8 government nominees. The institute is monitored by the Ministry of Corporate Affairs. Act was amended way back in the year 2006. So to copy a model from abroad on the line of Sarbanes-Oxley Act, I will not suggest that will be a good model. We need to keep in mind that look, this is a government regulator as on date. Now today the government says 32(8). Similarly, there can be issue with other regulating authorities also. Now we have a SEBI, we have a Reserve Bank of India also, etc. But all these bodies are managed by the human beings, and we need expert people of the subject. So that's why I believe the wisdom and the confidence and the expertise which the ICAI possesses should be utilized. In case there are certain issues on the power which ICAI has, as we discussed earlier, on implementation of Section 25 or 29, or giving punishment or discipline in the partnership firm as against the member or a corporate body, certain issues can be amended and the ICAI can be more empowered. So I will not suggest to have another body which will become another regulator. And we cannot copy the model, because what we see in America, where we have there is a body what we call CPA, and AICPA is the body there, which is a society and where government has no role to play with. So in those circumstances, it was appropriate to have a separate body or an oversight body where government has a say. In the ICAI case, the government has already a say in that profession. In their decision making and in their disciplinary mechanism. So I believe that mechanism can be strengthened, that can be taken forward. So it is not necessary to have something more than over and above ICAI as a regulator.
Mr. Jain, my last question. The Supreme Court wants the government to now constitute a 3-member special committee within 2 months to look into the entire regulatory framework of multinational accounting firms. And post the submission of that committee's report, the government has to take the due necessary action. I want to ask you, what should ideally be the composition of such a committee to avoid any potential conflict of interest?
See, I believe the Supreme Court direction is to the Union of India, and the Union of India will constitute this committee, and I believe they will take representative from all sectors and sections looking into consideration. People of eminence from the chartered accountancy professions, from the institute, they can be taken into consideration in this body. They can see what is, with a long experience, they can come up that yes, here are the issues, here are the problem, and dispassionately they can work it out, keeping in mind that what should be the role of the institute and how to regulate and how to ensure that there is a compliance of the law. We need to keep in mind what the issue before was a public interest litigation arising from a court in Karnataka and traveling to the Supreme Court, and the issue was that compliance of law should take place, and the petitioner has referred to the Supreme Court and relied upon the report of the ICAI itself, the report of the FDI, report of the Enforcement Directorate, to demonstrate that look, apparently there is a violation of law and still the issue is hanging, and it is not being taken to the logical end. So that's why I believe that the Supreme Court has given the direction. So taking into consideration all these issues, the group should have people from wide experience, and they should come out with a suggestion within a period of 3 months, and on that basis, whatever amendment and whatever the rules required, those can be amended.
Mr. Jain, thanks so much for taking out time and joining me on Amicus Curiae this week. Clearly, the ball is in the court of the government now, the regulator, as well as the enforcement agencies. Thank you so much once again.
My pleasure. Thank you, Jay. Thank you.
With that, it's a wrap on this edition of Amicus Curiae. Thanks so much for tuning in. This is Ashwin Mohan signing off. I'll see you next week.